So I'll start today with our first speaker is Jamie Pollack. And Jamie, can you hear me? Because when I stand up, okay, thank you. He's a graduate of Osgood Hall Law School. He graduated in 1993, was called to the bar in 1995. He joined the firm of Laxton, Glass & Schwartz and has continued there ever since. He's now a partner at Laxton Glass, which it is now called. His practice includes all aspects of personal injury claims, including first and third-party claims, disputes between insurers arising from first-party claims, and indemnity claims between insurers, such as loss transfers. He is a member of a number of organizations, and he speaks regularly at seminars on the topics of accident benefits. So if you could please give him a warm welcome, we'd appreciate it.
I thought when I was given my topic and time slot of 15 minutes, I was being punked, because those who know me know I can't speak for under 15 minutes ever. I spend more time in the Tim Hortons drive-thru lineup giving my order. But in any event, I'll do my best. I figured that my topic is predominantly on the word predominant. And given that I'm lead off, I thought I'd tell a little story about predominant and my 11-year-old son. Given that today's general topic is WTF, which I didn't think stood for Where's the Funding, but I guess it does. The other day I asked my 11-year-old son if he had finished his homework, and he said, predominantly. And I said, WTF. So he said, you know, Dad, predominantly, it means mainly, chiefly, largely, mostly, principally. And I said, oh, is that what it means? Why didn't you finish it? And he said, because I had to finish my homework from last week. So I said, oh, I get it. You had a pre-existing condition that hampered your ability. And he said, exactly. It's not like I don't know the stuff I still need to do. So I said, so it's not like you have any sequelae from your current homework that prevents you from finishing. And he said, WTF. Then he hit me up for $3,500 worth of hockey equipment, said he'd be back for more because basically his funding was unlimited. And that's the story of the MIG through the eyes of an 11-year-old boy. It also might be through the eyes of an adjudicator. The definition of predominantly has many but similar meanings when you look it up in the dictionary. What it means under the SABs and the MIG, nobody really knows yet. We can take a wild guess, but there really isn't any case law to guide us. And my biggest fear about the use of that word is, much like when they use any other subjective words in legislation, it is subjective. Just like when they brought in the threshold in tort claims and used the words serious and permanent, which don't necessarily mean serious or permanent, and they use the word reasonable in almost every paragraph of the SABs, and who knows what reasonable is. I certainly don't anymore. It's going to pose a significant problem, because what is predominant? But what I can tell you is that in order to get somebody out of the MIG, who might appear to have MIG-type injuries, you need to give compelling evidence. What's compelling? That's also subjective, it would seem. What might be compelling to you won't be compelling to the person sitting next to you. I don't necessarily know what compelling is, but I do know that it needs to be attached in the format of a treatment plan and accompanying medical evidence. So what I take from compelling is it means no begging, no whining, no phone calls. It means putting it in writing, getting the treatment providers, the healthcare practitioners to reduce their thoughts to writing. And unlike what we see in many reports where it's the same old, cut and paste, insert the name here, it has to be specific to that injured person. If you are acting for an injured individual, you don't want the same old every time the same healthcare practitioner authors a report that is supposed to be compelling evidence to try and get your client out of the MIG. That's not going to help anybody. You want to have good reasons, sound reasons as to why the MIG ought not apply to that person. And when we look at what predominant means, and we look at compelling evidence, and we look at what it takes, we know that it has to be compelling evidence in relation to pre-existing injuries or issues that would prevent them from recovering or reaching their maximum recovery under the MIG. So you have to have them speak to that. And if they don't speak to that, you're going to have serious problems convincing anybody, let alone the claims person, that the person ought to be out of the MIG. Remembering that the claims person, just like the rest of us, currently has no case law to guide them on the definition of predominant or the idea of compelling evidence. And you know that you're going to have to present that evidence at some point at... Can't hear me? Wow, sorry. You know that you're going to have to present that compelling evidence at some point, if not now, then at a hearing, so you may as well get it now and get it right. It has to attach, as I said earlier, for those who didn't hear, it has to attach to the pre-existing condition. It doesn't necessarily or really matter about post-accident, but rather pre-accident. So you have to have them speak to why it is that that person should be outside of the MIG based on a pre-existing condition, a real pre-existing condition, that prevents them from recovering or reaching their maximum recovery if they're governed only by the MIG. The other issue you're going to have to address is when dealing with the psychological type issues, are whether or not the psych issue is the predominant issue. Because sometimes your psych issue will be the predominant issue. And examples that I've used to try to demonstrate the difference was looking at a case where you have a soft tissue type injury that develops into a chronic pain situation or psychological overlay type issues. And there you're going to have the potential argument or dispute over whether the psych issue is forming the predominant injury, as compared to an example whereby you have an individual who's in an accident, suffers what would otherwise be soft tissue type whiplash type injuries, but they also witnessed in the accident a fatality and now have serious psychological symptoms because of what they saw. And it may be that those psychological issues are actually worse or greater than the physical injuries. And in those circumstances, you may very well find that the psychological injuries, which are the predominant injuries, take the person out of the MIG. The concern here is for a real critical analysis, because if you get it wrong, it is not only going to take a ton of time to find out that you're wrong, it's going to be very, very, very expensive. And as we know, with the backlogs at FISCO and the issues with the mediation unit and then getting to an arbitration or a trial through the court system, it's going to be way too late for your individual who's been injured and needing treatment to find out whether or not they're in or outside of the MIG, and then offering them some additional treatments 3 years after or 4 years after the fact. So what you have to understand is, if you're acting for the injured person, or if you're a healthcare practitioner assisting an injured person, you have to develop the compelling evidence. It has to attach to pre-existing conditions as compared to post. However, if the post-accident condition, psychological condition, is something that is so significant, then you may end up getting them outside of the MIG on the basis that the psych issue is the predominant issue. The most interesting part for me about reading the MIG when incorporating into the SABs is they provide a slew of definitions. But when you look at those definitions, by and large, the definitions are all in relation to medical issues and medical definitions. They define sprain, they define strain, they define subluxation, they define whiplash injury, whiplash-associated disorder. They go so far as to try to explain functional restoration, but they missed predominant. And that would have been the one that I would have liked most. So that's going to be the biggest problem. And I think that you'll find with adjudicators, they'll look to apply somewhat a basic Webster-type dictionary definition. And it's going to be up to you to show how that affects the client in relation to the MIG, and I think that's going to be most important. When you look at the MIG and you look at the motherhood statements about what the MIG is for, it sounds kind of like the PAF, just a little different lingo. And frankly, I don't quite understand. I think it's a distinction without a difference, or a difference without a distinction. The idea behind the MIG is to remove what they say is, by and large, most of the injuries that people suffer in car accidents in Ontario from big type of payouts. Well, I thought that was the idea behind the PAF, and we all saw how that worked out so nicely. And so, as I mentioned, I spoke at a seminar a little while ago with my good friend Adam Wagman sitting beside me as my fodder. And as I said, I think what they did was they took the MIG and stuck it up our PAF. But I tend to think that it really is just another attempt to legislate out what is in essence the soft tissue type claims. That's what they're saying. But then they're going to put this in the hands of adjudicators. And we all saw what happened with the PAF. And so I think that we are going to have a lot of fights. I think that, I know that we have some. I have some files already on the go under the MIG where my clients are adamant that it's a MIG file, at least based on the evidence to date. And as I say, that gives rise to another problem, because what do we see? The evidence to date. And the evidence to date suggests MIG. And then you get to the cusp of a hearing, and you get inundated with lovely reports that are suggesting that the person shouldn't be under the MIG, and the various reasons why. Something akin to compelling evidence. Well, why wasn't that presented a year or two earlier? So you really got to stay on top of this, because the delay in treatment is just as bad as no treatment. So if you're going to act for people or work with people who are potentially in or outside of the MIG, you're not doing them any service by waiting, and then dumping the compelling evidence at the last minute. So you really have to get your healthcare practitioners, if you're the lawyer, you got to make sure that they understand what the MIG says, understand what the evidence is that is needed, if it exists, and to get that to the claims person as quickly as possible. If you're the healthcare practitioner, you have to understand what the definitions are, including predominant, good luck, and get it reduced to writing in the face of the claims person as quickly as possible. Phoning the claims person and explaining it to them is, in my mind, not going to be of any assistance. Number one, it clearly is not something contemplated under the MIG. And secondly, the claims person isn't going to be able to wave a magic wand and say, okay, I agree, they're outside of the MIG. So just reduce it to writing and get it to them, as quickly as possible. Anything else, you're doing a disservice. And if you're the claims person, you have to read those reports, obviously, and really understand the individual in the context of all the medical evidence, and whether or not the injuries sustained in the accident are MIG-type injuries, whether or not there really are pre-existing issues. And on the pre-existing, if there really are pre-existing issues, you'd think that there would be some pre-accident health records that speak to it, at least to some degree. It's going to be, I think, a difficult challenge to some degree, proving that the person had a pre-existing issue when they never had any treatment for it. And it doesn't appear anywhere in the clinical notes, doesn't appear anywhere in an OHIP summary. So you're going to want to, as a lawyer, investigate that as well, because you don't want to bark up a tree if there's no evidence to support your case at the end of the day. As I often say, fight the good fight. Fight whatever fight you like, because ultimately it just makes work for me. But if you're going to do your clients the best service, fight the good fight, and that is the ones where you actually have real evidence, good evidence, and then put it forward quickly. So hopefully now when you all leave the room, you'll have a firm understanding of the word predominant, and I believe I'm going to bring the train right into the station on time for you, Renee.